An advocate has the ability to change injustice to justice and weakness into strength. Good morning, ma'am. I would like to welcome you to Career Talks. And the topic for today's discussion is Advocates on Record. Ma'am, I would like to request you to introduce yourself.
Thank you. I'm Akriti Chaubey. I've been an advocate on record. I qualified the exam. I gave the examination in 2018. I qualified. The result comes after a year. So I qualified in 2019. And before that, also I have been practicing in the Supreme Court since 2015. And before Supreme Court, I was doing international investment treaty arbitration, and I was working with a law firm called DMD Advocates.
Okay, thank you, ma'am. So, how would you describe an advocate on record? Who are they?
So, advocate on record is a normal advocate plus an advocate who has passed the advocate on record exam with the Supreme Court, which basically you have to have a certain kind of experience for it before qualifying even to take the exam. So that is one qualification for it. And Supreme Court, once you pass that examination, the court entrusts you with the responsibility of filing and handling the files of a client in the court. So no one else apart from an advocate on record can, file a wakalatnama on behalf of a client in the Supreme Court. In the Supreme Court, even a senior advocate cannot directly appear for a client until and unless an advocate on record engages him to appear for the client. So on the wakalat in the Supreme Court, you cannot have a normal advocate signing the wakalat. Only an advocate on record can sign a wakalat. Only an advocate on record can file petitions in the Supreme Court of India.
Okay, so very well. And so an advocate yourself, can you please share your experience in this field? How did you start and how is it going?
So yeah, it's been a very topsy-turvy journey. I think in this profession, no one can say that you have a straight graph. So I qualified in 2012, and I had been interning intensively. I had interned twice with DMD Advocates beforehand, and when I applied for a job there, I was lucky enough to get a job in DMD Advocates because it's one of the best firms, especially for females, I will say, where you get trained by such senior people, and they don't see how many years you have in the profession, but if you have the caliber, they will give you the most important work also to do. So that way, it was a really good experience. I'll say the kind of exposure I got in my from 2012 to 2015. I was doing investment treaty arbitrations at international level. We were working with lawyers from London, and we were traveling to London for arbitrations. And a person of who's just out of college, no firm would have trusted them with such a such a vast matter, but they did, and I got a lot of exposure, and especially I'll say that I was under Miss Anuradha Dutt's team, and she's a taskmaster. She's like, I have no words to describe her. She's brilliant, like brain wise, work ethic wise. All my work ethic, I'll tell you, in the profession till date, which I have, that work ethic I have developed only from her. She taught us that, when there is work, you have to put aside everything. I've seen her, in personal tragedies. She has come to office, she has worked, and she has delivered. So that is something that I also, I strive to be like her someday. But so that's how I started. So in 2015, I was only doing investment treaty arbitrations with the DMD Advocates, and I wanted to get some, hardcore litigation experience. People you always, even after you come into the profession, there's always bullying. People say, tum to asli vakeel hi nahi ho, tum court nahi jaate. There's always that kind of bullying going on. And I got bullied like that a lot. And then I thought, what is this litigation? Let me try this out also. So people would call me mad, but then I left a perfectly fabulous job at DMD Advocates, and I jumped into litigation. So this job also in litigation, how I got, I had interned with Mr. Ejaz Maqbool once in my college days, and he happens to be be the father of one of my college classmates. So that's how I had gotten the internship. I have no law background. I'm a first generation lawyer. So that's how I had gotten the internship. He remembered me from my internship days, and he also had an opening at that time. So it fit perfectly, and I shifted to this practice. Over here also, he's also one person who I've been very lucky that way with all my jobs, in the sense that I have always worked under people who will not see how much year or how much experience you have, but if they feel that you have the caliber, they will trust you with the matter. So I joined Mr. Maqbool, and I got to do several large-scale Supreme Court litigations in which he gave me like complete free hand to handle, brief the senior, decide the strategy, make the written submissions, everything. So after 2015, I joined there in August. And I think within 2 years, I had done so much litigation. And then the triple talaq case came and he trusted me completely with it. And I mean, we had the free hand to brief Mr. Sibal. And of course, he would supervise, but it would not be like, see, once you are assisting someone, it's a different thing. They tell you what to do and you do that. But that is not the case in the Mr. Mahboob's office. You also have a say in what is the strategy going to be in the matter. And after the work that I did in the triple talaq matter and the entry tax matter, then came the Ayodhya litigation. And this is one litigation I have to be thankful to this office for, because they gave me complete free hand to brief Dr. Rajiv Dhawan. And if someone wants to learn any sort of law, you have to go to Dr. Rajiv Dhawan. He is the constitutional expert. I mean, the kind of preparation at his level he did for that matter, I don't think anyone could have done that. If I'll just give you an example. Suppose you're challenging constitutionality of a law. You know how he will prepare. He will go through all the judgments that are there on that act. What is the legislative intention? Why did that act come into being? What is the international scenario? He will know everything about it, everything. And then he will see what the case is about. The background, he will go so much. Even if he has to write an article today on freedom of speech, he will go into when the first article on this topic was written. What is the first writing? How this has been developed? He will do that kind of research to even write a small 2-page article. So that was one really, really good experience. I think it it helped me develop my skills tremendously. I think that 1 year that I worked with him on Ayodhya was equivalent to all my years before, and then it was really good. So that's how and with that case, I got a lot of fame also, in the sense that people started to recognize me in court, etc. And so after that, I started getting a lot of my independent matters, and that's how it's been since then. I've been doing my own practice, and I've also been with Mr. Bakbul, so balancing the two.
Yeah, that was very wonderful to hear and exciting to hear your journey. So I would like to ask you, what is the basic difference between a normal advocate and an advocate on record?
See, as I said, a normal advocate you become once you clear, you get your degree, then you enroll yourself in the bar council, then you give your bar exam, and after that you are pretty much free to appear anywhere. You can still appear in the Supreme Court, but you cannot file a matter. For filing, an advocate on record only can file a matter in the Supreme Court. In the High Court, suppose, if you say High Court or any other tribunal, NCLT, NCDRC, any advocate can file a wakalat and file a case. But that is not the case in the Supreme Court. In the Supreme Court, you have to have this advocate. An advocate on record only can file a wakalat now.
Okay, so being an advocate on record specifically, what is the eligibility criteria for becoming it?
So the eligibility criteria is technically 4 years of experience plus 1 year of training under an advocate on record who has 10 years of standing, more than 10 or more years of standing. And after that, you become eligible to fill the form, then you fill the form, and then you give the exam. Exam comprises of 4 components. But hota kya hai na? So you have 4 plus 1 years. So most of us, we call our law college final year ends in April or May or something, and we start practicing in July. But the form submission date for AOR exam is such that वो है तो 4 plus 1, but the date is such that it is before May, sometime May or before May. So it actually, in practicality, you're not able to complete your 4 years before you have to start your training. So what happens is, once you complete, in theory, once you complete 4 years, but in practicality, it becomes 5 years because of that form date thing. So you go to an advocate on record, you take a letter from him. It's saying that this person is going to start training under me for the advocate on record. It's called an initiation letter. That letter you take, then you go and submit that letter into the record office in the Supreme Court. Okay? Yeah. After that, your training begins. After 1 year, then you have to again take a letter from this advocate on record. And there are several other documents also, a bar council certificate and bar enrollment and a certificate of good standing, etc., that you have to submit along with the letter of initiation. After that, once your 1 year training is complete, then you have to submit a letter of completion. That same AOR will say that, this person has started, 1 year has completed, and then you fill your form for the advocate on records examination.
Okay.
So after that, once you fill the form, then you have to take these 4 exams, which are there are 4 subjects: practice and procedure, legal ethics, legal research, and drafting. So practice and procedure is basically about your day-to-day functioning of the Supreme Court, in which basically you have to master the Supreme Court rules, how to file, where to file, what exemptions can be granted by the registrar, which can be granted by the chamber judge, which can be granted by the main court, how many days, limitation. If you have to get a matter listed urgently, how will you do it? If a client comes, and the exam is very practical in the sense they will give you a situation and they will tell you, they will ask you, if the client comes to you and this is the situation, what rule, how will you proceed? So in that you will have to say how I will file, how much days I have to file, if suppose you come for an SLP, so kitne din ka limitation, and you have to mention all of that in your answer.
Okay.
So it's a very, of course, there are some theory questions, but most of this examination, if you are really practicing in the Supreme Court, this practice and procedure examination is based on your day-to-day, how to get your defects cleared. These small things, which if you don't practice there, will be very difficult for you to understand. But if you practice there, it will be something that you do on a daily basis. So it will not be difficult for practice and procedure. For practice and procedure, mainly you have to master your Supreme Court rules, and there's a handbook of practice and procedure. It's available on the Supreme Court website only, which has everything about the Supreme Court, every possible procedure that is there in filing, defect, etc. It's all there in that handbook, so you can read it from there. The second exam is drafting. So now, and also all these exams are back to back, okay? So you don't get any break in between, and you have to handwrite all these exams. So a major problem which comes to most of the candidates, that they will be knowing the answers, but they are not able to finish the paper. These papers are extremely lengthy, extremely lengthy. You will get hand aches while writing, because you're not, after 5 years into the profession, no one has the habit of writing a paper by hand. I have never missed any question or etc. because of time reasons in my entire life. And the first paper that I wrote was practice and procedure for the AOR exam, and I was not able to complete, like 12 marks. I had to just let go because I wasn't able to complete the question. But that's what goodness gracious that I was able, by God's grace, I was able to pass that exam. But so that is a real problem. In drafting, then what they make you do is they give you actual situations. They give you facts for some SLP or for some transfer petition. 4 questions, I think 4 or 5 questions they give you. And you have to write the entire draft. Like even the cause title, etc. In the top you write in the Supreme Court of India, all of that has to be handwritten. Even when you're practicing day-to-day basis, all of that you're not always typing on your own, that all your steno does. You just make the office and the grounds. No one bothers, but all of that is actually checked, so that why do they have this exam? This exam is so that when the petitions are filed in the Supreme Court, there is some basic quality. The judges don't have to, run around for what are the facts, what is this person written in English where they are not able to understand. So there is some basic quality is maintained, because, you have to understand that all courts in India and Supreme Court also, they have such high volume of matters. We can't even imagine how much work judges do on a daily basis. They work a lot, for one day, even if 4 or 5 of our matters are listed, we feel so, nervous that 5 matters are listed. How are we going to prepare? For them, or the whole list is listed, like 50-60 matters at least are listed, and they all read and come. You will, I don't think you will find any judges in the Supreme Court who don't read and come. They all read and come. So it's a whole 50 matters. Imagine that person is reading. If there's no basic quality, how is he going to cope? It's not possible. That is why this exam is there. So drafting also, you have to write the entire thing. Then there is one exam of legal ethics. Then usme to, you have to talk about basic, like can you go. In our time, there had been 2-3 back-to-back strikes of advocates, so they had asked a question about that is it ethical or not. Like they give you very practical situations, like if a client comes to you and he tells you to bribe the registry official, is it ethical or not? It's basic practical questions they are going to ask you. The last exam is legal research. Now to prepare for this exam is a Herculean task, because it has Supreme Court's landmark judgments around in our time it was 44 judgments, I think, and this year they've increased it to 60s. And they're all big judgments, like S.R. Bomai, Keshav Nanda Bharati, they're all big judgments. But if you are, really a litigator, you will have the time of your life preparing for this legal research. This was my favorite paper because after reading all those cases, even though all of those are taught to you in college, etc., you feel that you immediately know so much because then reading those cases from a different perspective.
Yeah.
And all of those cases are there. And this is an open book exam, legal research. They give you the case notes of all the cases which are there.
Okay.
So, but in reality, when you're writing the paper, you don't have the time to even open those case notes. You have to
Yeah.
remember.
It's lengthy.
So, if you don't remember, it's not possible for you to go to these exams. So, these are the 4 exams that you give. And yeah, I don't remember opening the book at even once in the legal research paper. I couldn't because there was no time. You have to finish your paper, so you need to remember. So, and even in legal research, etc., they will not ask you one case. Like they will ask you, for instance, how's the basic structure doctrine works. So you start from like Kisanda Bharati, etc., and you go on till like last was NJSC judgment when we had given the exam, which had used that
Yeah.
doctrine. So you trace everything, so you understand the actual development of law. For reservation, they'll ask you the same thing. So you go from the first case to the last case. They are not looking for you to mug up the facts and vomit in the paper. They will ask you
Yeah.
evolution. They will ask you what is your view. Is this doctrine okay? Is this doctrine not? Is this doctrine being correctly used?
Yeah.
So this is it is not a standard college exam that you give. You have to
Mhm.
be in practice. You have to apply your mind. Then only, and anyone who has understood the concepts can only clear this.
Yeah. They use the practical aspect more.
That's right.
So, okay, after becoming it, so what kind of legal work they have to handle, the advocates in the record?
Advocates on record do everything under the sun. See, anything which goes to the lower court ultimately and on appeal comes to Supreme Court. And
Okay.
though Supreme Court was originally envisaged as a constitutional court to decide constitutional questions of law, unfortunately or fortunately, I don't know, but it has become an SLP court now. Most of the work that the court is doing on a daily basis is based on a special leave petition, which is nothing but that people who are losing in lower forums are filing special leave petitions to challenge those orders. So you can, do tax matters, criminal matters, environment matters, everything at the same time. And along with that, you could be doing, matters of national importance, like, suppose the CA challenges there, or, all these
Yeah.
legislations which have anti-tax matter, legislations which have pan-India importance, and, you could be doing those. You could be doing original suits between 2 cases, like Punjab and Haryana water dispute. So, the area is so vast, it's endless opportunities.
Yeah. So, okay, so when one can start aiming for this as a career option?
So, see, first you have to get into litigation. See, you have to have like 4 years of experience to basic before you even start the
Yeah.
initiation procedure. But
Yeah.
I would say that after, 1 or 2 years in the lower courts, if you really want to be an AOR, and then, though on paper they want only 1 year initiation, 1 year period experience under an AOR, I would suggest that after 2-3 years of lower court, do at least 2-3 years of Supreme Court and then take the exam. Because if you do 2-3 years in the Supreme Court, then the only exam that you have to prepare for is probably legal research, because all the cases you wouldn't have probably read at the same time. It's difficult to recall. Rest all drafting and practice and procedure will be a cakewalk after that.
Okay.
If you
So,
can write the answers, though, you have to while preparing, you have to write and prepare. Otherwise, it's not possible. Even if you're the most brilliant person, it's not possible because you're not able to write.
okay. So, is there any future prospects for this field where a student can look into after aiming for this as a career option?
See, of course, once you become more seasoned AOR, if you're arguing also a lot, there's always the regular options are always there. You may be designated as a senior advocate, or, if you're a really good AOR, maybe right now there is this proposal going on, very controversial, that they are considering Supreme Court
Okay.
lawyers to be designated as High Court judges. It's not like like never happened before, but it used to be very extremely occasional. But now they are considering, like, to set up a search committee. So that is always there. And you can aim for the best. Even President Cohen used to be an advocate on record in the Supreme Court. I don't know if you're aware.
I know, I
So
know.
he used to be an advocate on record.
Okay.
So all, I mean, the usual options are all there. You be a senior and you can argue, and if you are lucky, I mean, if you're also practicing in high court, there are chances of elevation. All of that is there, like the usual options.
That's wonderful. Having future prospects always motivates a person. So lastly, I would like to request from you to kindly share some advice for students or advocates who aspires to become an advocate on record.
See, there is only one. There is no substitute to preparing. You have to write and prepare. For drafting exam, everyone was telling the next day there was drafting. You don't really have to prepare anything because you know the format. But the only thing that you can prepare is writing. So there are no gaps in between the exams. Even when I qualified my law from Symbiosis Law School, Pune.
Okay.
And even in Symbiosis, we used to have no gaps. All exams used to be back to back. So if there were 8 exams back to back. We used to have no breaks in between, except for if there was a Sunday. Otherwise, no breaks in between. So I was kind of used to that format. Many people are not, because some colleges, they give you prep leaves in between exams, but that is not the case. So of course you have to prepare in advance, but then in those days you have to keep on writing. And especially in drafting, so many people I know lost out only because they left one question. And in drafting, one question is 20-30 marks. If you're leaving one question, then it's sure that you're not going to qualify. So apart from having the practical experience, which I mentioned earlier, that at least you do 2-3 years under an AOR, that is much more better. Do your lower court experience. It is very important. There is no replacement for it, because it will always help you understand procedure better. But from exam perspective, after doing your 2-3 years in lower court, high court, do 2-3 years in the Supreme Court, practice over here, and do everything, go along with your clerk everywhere, wherever he's going to clear defect, if he's going to file process, go do all of those things. In my first year, Mr. Bakbul had given me such training. When I had joined, I had come from a fancy firm, and what, he made me clear the defects also of each matter. Before that, I had filed matters in the Supreme Court. I had never even known that there is something called defects, because our clerk used to do it. I had no idea. But he said that if you go and clear the defects, you will improve your drafting, because you will know that what kind of objections registry is marking, and then you will not make those mistakes in your drafting.
Yeah.
So it's very important, we never give much importance to the work that clerks do, but in reality about the practice and procedure, they know more about it than the advocates. So if you have to clear that paper, you must accompany, at least the first year that you join your AOR, you must accompany the clerk everywhere. He will go to the registry to do 100 things. You must accompany. You will know which sections are there. Where is the defects counter? Everything. Where is the filing counter? If there is an urgent mentioning, where do we send a letter? Everything. So right now everything is online, but everything is by email or phone call, which only AORs can do. But other than that, you must really do that. You must accompany your clerk. So that is for practice and procedure. For legal ethics, you need to read the book and also have the right bent of mind. But you really need to read the book. Then for drafting, of course, you will have, once you've done 1 year with an AOR, it's more than enough to understand what drafting is. But while preparing for a drafting, don't think, while we are preparing for drafting, people when they are preparing in advance, they don't usually allot days for drafting preparation. They think isme to kuch prepare hi nahi karna, these formats I am already aware. But you have to keep 2-3 days aside to practice old question papers by hand. If you do that, and you have to time yourself, you have to see that you complete those papers. Right? That is the only preparation drafting requires, to be in time. And for legal research, I would advise, if you're preparing for that, don't see, the list is very it's not properly it doesn't properly segregate cases topic wise. So do take your list of 44 or 60, I think it's 61 cases now, I'm not sure. In our time it was 44 cases. So you need to segregate those cases topic wise, all reservation cases together, all basic structure cases together. Like this, you have to segregate the cases. So then you have to arrange them in ascending order. After that, when you will read those cases, you will understand the entire evolution of law. That in the previous judgment they said this, in this judgment they have said this, now they are saying this. So that is how you will understand. That is the true intent of behind that paper, to understand the concept. If you are going to read one judgment here and one judgment there, and without arranging them in order, without topic wise, your mind is not going to retain anything, because unless it is in form of a story, it is in form of a slow, you will flow, you will not understand anything. So I would really, this is a tip that one of the seniors who had taken the exam before me had given to me, and I found it really helpful to arrange the cases topic wise, because before that I had already started preparing and I was not able to retain anything, especially in reservation law. I was not able to retain anything. Then I was just having a word with the seniors in the court. We was chatting. So he said, for the cases you do one thing, you organize them and then you read them. And I found that the most helpful tip ever. After I did that, I don't think there was any case that I did not remember. And I made my handwritten notes on each topic. Reservation ka har saal question aata hi aata hai. Basic structure ka har saal question aata hi aata hai. So all of those I made handwritten notes, so that when the question comes, I don't have to think. It's all ready in my head like a format. So that you have to do. And most important is that before the exams, 1 month or 2 months before the exams, they organize some lectures for AOR exam preparation.
Okay.
There's, they call senior advocates and, very experienced AORs to give the lecture. Must attend those lectures. In those lectures, they discuss the most important topics. And I have seen in my experience, at least, that the topics that are discussed there, they will find place in the paper. So, that is something that you need to attend. You cannot afford to miss those classes. And I think from our times, they have become very advanced. They put those lectures on YouTube also. So even if you're missing the lecture, which I will strongly advise against, you can see it from YouTube. And at least those topics you must prepare. The syllabus is vast. It may happen that people, due to personal difficulties, don't have the time to prepare everything, which I will not again advise, because you waste a year, then it's a whole thing to prepare again. If you get I've seen people who've given the exam twice and thrice, and it's really not a good experience. Touchwood, by God's grace, I was lucky that I qualified in one time, because if I would have had to prepare it again, it would have been it would have been very demoralizing for me. So if due to any personal difficulty, you're not able to prepare for the entire syllabus, at least you should know everything that was taught in the class. At least those topics you must know by heart.
Yeah. Oh, that was really helpful as a law student myself. So I'm sure that would have benefited the people listening to it. Thank you so much, ma'am. It was very delightful to have you here, and very kind of you to come here and share your experience here. Thank you, ma'am, again.
Thank